Justice Barrett?
So in your understanding of Twitter, would it be enough for contributory vicarious liability, aiding and abetting, if Twitter knew that a particular account was being used for child trafficking and didn't take it down, didn't cut the user off? They know it, but they're not doing anything to facilitate or encourage. Twitter obviously has lots of other purposes.
So I think that's a hard case. I don't know how Twitter would come out on that, but everything Twitter said about affirmative conduct and malfeasance versus nonfeasance, I would say would drive the conclusion the same way that Twitter ultimately drove it. Now, I can imagine this court someday carving out an exception for life and limb or imminent danger of physical harm.
But your basic answer is that, based on your understanding of Twitter, unless we carved out that kind of exception, your theory of aiding and abetting liability anyway is that there would not be liability.
That's correct. I mean, this court said in Twitter what I said right at the outset of my argument, that plaintiffs have identified no duty that would require communication providing services to terminate customers, terminate them, after discovering that the customers were using the service for illicit ends. I'm just reading what this court said in Twitter.
Well, you know, Justice Kagan is right that in Twitter and in Smith & Wesson, it was a bit more attenuated. You're putting it out in commerce, but the knowledge link was not as strong as in the hypothetical I gave you or in the hypothetical that Justice Jackson gave you. Do you understand aiding and abetting liability to be coextensive with the kind of contributory infringement liability we're talking about here? In other words, is anything that we say here, if we adopt your theory here, is that necessarily going to carry over to the aiding and abetting context?
I would think so, Your Honor. This court has always treated those two lines of cases interchangeably. When this court asks what the common law is of copyright contributory liability, it is looking to, back to Calum, accomplice liability. So what this court says here will apply to other contexts, except if there's a statute that changes the common law, and vice versa. What this court said in Twitter and in Smith & Wesson should apply with full force to this version of common law liability.
Last question, and this is a record-based question, just so that I can be clear on how this works. So this department that sends the notices, the one that Paranoid Panda, the employee, was concerned about, is it dedicated entirely to copyright infringement, or is it also detecting accounts and taking them down either because of failure to pay or other kinds of things?
So, Your Honor, it's called the abuse team, and so it tracks all sorts of abuses. It got 5.7 million notices in the particular period. It was reacting not just to copyright, but to the point I was beginning to make earlier. It reacts to phishing. It reacts to fraud claims. It reacts to hacking, none of which there is a legal duty to act.